Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Whoo, child. Um, Give me 1 second. I'm in a paralegal group, so I'm just trying to see in regards to this Diddy stuff. The judge. Oh, shout out to her. Yeah, we have a whole conversation in these in my paralegal P. Diddy chat with other paralegals. So, one of the paralegals stated that the judge in the case signed a motion allowing the attorney to file as a Jane Doe. This was in the petition before Sean Carter, aka Jay-Z, was added. She stated that she's read that in SA cases they can file as Jane Doe, but they do have to tell the defendant who the person is. So they already know who the individual, who the Jane Doe is. However, when they are filing any type of pleadings, they are able to use the pseudonym Jane Doe. That's how that works. Okay, so there has a lot, a lot has transpired since the amended petition was filed by Tony Buzbee, and I believe I did like a little update this morning, just trying to tell you guys exactly how the process goes and why it's not a criminal complaint and why it's a civil complaint. And I showed you guys the statute of limitations on both of those. So going into today, early this morning, and actually last night. So after the petition, the amended petition was filed, there were more documents that was filed, and that's what we're about to get into. So there was one, two, three, four, hold up. Let me see. I don't know why it says that, but that's weird. Okay. I had to label these by the docket number so I can ensure that I go in order. So let's hop right on into this. All right. So first and foremost, we have the declaration. So after the amended complaint was filed, uh Tony ended up filing a declaration in support. Well, before we even do that, he filed a motion to continue this litigation case under Jane Doe. All right. And so, in order to file a motion, you also have to file the declaration, in which he did. So, this is his declaration on the plaintiff's motion to proceed anonymously. So it says, I am the owner of the Buzbee Law Firm and counsel for Jane Doe. I make this declaration in support of plaintiff's motion to proceed anonymously. If required by this court, I would disclose the plaintiff's name to counsel for defendants. However, I request the hearing prior to any such order. Plaintiff Jane Doe was a minor, age 13, at the time of the incident occurred. Plaintiff is by no means the only victim of Mr. Combs to fear violence in retribution for coming forward. My firm currently represents over 200 clients with claims against Mr. Combs. Strikingly, an overwhelming number of these clients, likely in excess of 80%, have stated to me or attorneys at my firm during their intake process that Mr. Combs made threats of violence against them or against the client's family member if the client disclosed to anyone the facts of the essays or other acts of Mr. Combs of which they were a victim. For many of the clients referenced above, Mr. Combs' threats of violence were a primary reason why they did not speak out or file lawsuits earlier. Most of our clients still fear retribution and have conditioned moving forward on anonymity. So they want to remain anonymous, in which they do. This is not uncommon. Okay, I just want everybody to know that this is not uncommon. There have been cases that I have had the pleasure of working on with different attorneys and different firms where they are anonymous because now they, to us, because some of these, well, majority of these documents are going to be public records, so they don't want the public to know, but as long as the defense know who the person is, that's all that matters. um Secondly, as it stated before, we have to understand the type of situation that's going on. Sean Combs has made threats and continues to make threats. Look at everything that he is doing right now in in the jail cell, in the facility, right? He's trying to get a laptop, and we already know what he's wanting that laptop for, not just to go through the discovery, but also to connect to people on the outside world. He's using his family members. He's using other inmates' PAC counts to connect to other people. He's still doing stuff that he is not supposed to be doing in order to intimidate witnesses and the jury. So therefore, I personally don't find it out of the ordinary, and it's okay for these women or men to come forward and use pseudonyms John Doe or Jane Doe. It is for their protection. As I stated, I don't put anything past Sean P. Diddy Combs. All right, so that was the declaration to support the motion that was filed to continue this case under Jane Doe. Let's see. All right, that was the declaration. This is the memo. And I'll briefly go through this. So yeah, we're gonna be on it. So if you're on lunch, we reading. All right. So this is the memo, the memorandum in support of the plaintiff's motion to proceed anonymously. So plaintiff Jane Doe, by and through her counsel, the Buzbee law firm, hereby files this memorandum of law in support of plaintiff motion to proceed anonymously pursuant the federal rules of civil procedure. The lawsuit involves claims arising from defendants Sean Combs and Sean Carter, essay and grape of plaintiff in 2000. In her first submitted complaint, plaintiff alleges that she was drugged and then assaulted and raped by Combs and Carter at a party following the VMAs. Plaintiff was a minor at the time of the occurrence, just 13 years old. Hey T, what's up? Because of the irregulous nature of what happened, plaintiff filed the lawsuit under the pseudonym of Jane Doe. There is no prejudice to Combs, Carter, or any other defendant if plaintiff is permitted to pursue her claims as Jane Doe, and if required by the court, counsel for plaintiff will confidentially disclose her name to counsel for defendants. Okay, she has the right to do that. As set forth in the complaint, Combs has a history of violent and aggressive behavior and has been the subject of numerous civil complaints. Let's see. Currently, Combs is in jail awaiting criminal trial on charges of sex trafficking and racketeering, among other things. Combs and the people within his organizations are dangerous. And we have read, so I had to stop reading these complaints because they were literally depressing and they will take a toll on you. Um, but the complaints that I have read, you see how did he do these people, these women and men. All right, do I want to go into this? I'll go into this so you guys can understand why they have the right to use their pseudonyms. So their argument, it says it is well settled that it is within the sound discretion of the court to allow a plaintiff to proceed anonymously in judicial proceedings. So they cite EW versus New York Blood Center, Doe versus Smith, which vacating on rehearing and modified on the grounds. And then it says that a district court has discretion to grant an exception to the general requirement of disclosure of the names of the parties to permit a plaintiff to proceed under a pseudonym. And then they said sealed plaintiff versus sealed defendant. So both of them, these records are sealed. But in that particular case, internal quotation marks and citations were omitted, alteration adopted. The question for the district court is whether a plaintiff has a substantial privacy interest that outweighs the customary and constitutionally embedded presumption of openness in judicial proceedings. All right. All right. So the first part, plaintiff should be granted leave to proceed anonymously in this lawsuit due to the sensitive and personal nature of these allegations. Plaintiff's interest in anonymity outweighs any other factors that would justify disclosing her name. When deciding whether a plaintiff may be allowed to maintain an action under a pseudonym, the plaintiff's interest in anonymity must be balanced against both the public interest in disclosure and any prejudice to the defendant. In balancing these interests, courts consider several factors, including the following non exhaustive list. So they consider the following: whether the litigation involves matter that are highly sensitive and of a personal nature, whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non parties, whether identification presents others harm and the likely severity of those harms, including whether the injury litigated against would incur as a result of disclosing the plaintiff's identity. So that goes with bringing harm to not just you, those around you. So you have to also take them in consideration. Whether the plaintiff is particularly vulnerable to the possible harm of disclosure, particularly given his or her age, whether the suit is challenging the actions of the government or that of private parties, whether the defendant is prejudiced by allowing the plaintiff to press his or her claims anonymously, whether the prejudice, if any, differs at any particular stage of the litigation, and whether any prejudice can be mitigated by the district court. Whether the plaintiff's interest has thus far been kept confidential, whether the public's interest in the litigation is further by requiring the plaintiff to disclose his or her identity, whether because of the purely legal nature of issues presented or otherwise, there is a typical weak public interest in knowing the litigants' identities, and whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. So a district court is not required to list each of the factors or use any particular formula as long as the court balances the interests at stake in reaching its conclusion. When balancing these interests, these factors favor granting plaintiffs' request to proceed anonymously in this action. All right. And then it kind of further breaks down as far as each of these, and I'm not going to go through that because it's pretty long. It's pretty lengthy. Um, Let me see. And I'm just reading these docs for the first time with you all as well. So they're trying to see if there are any. Conclusion: for these reasons stated herein, plaintiff respectfully requests that the court grants plaintiff's motion to leave. Okay, so what they did is, let me see, that's all the way through E. How many of these were? Oh, yeah. So out of these, they actually stated which ones would apply to this case. So, one, this litigation involves matters that are highly sensitive and of a personal nature. Hey, T Love, what's up? The second reason, the plaintiff's identity poses a risk to of retaliatory physical and or mental harm. Um, Defendant Combs and the other defendants will not be prejudiced by allowing the plaintiff to pursue her claims anonymously. Let's see. They also stated that the public will not be prejudiced if plaintiff proceeds anonymously. And allowing plaintiff to proceed anonymously furthers public interest. And let me read this one. It says the courts favor granting anonymity in these circumstances, as allowing plaintiff to proceed anonymously furthers the public's interest. The plaintiff requested that she be able to proceed anonymously. As here, the plaintiff in Evans, and that's the Doe versus Evans case, was a victim of SA. In considering the public's interest, the court determined that the public generally has a strong interest in protecting the identities of SA victims so that other victims will not be deterred from reporting such crimes. Plaintiff requests the same consideration here to protect her identity, and she would suffer significant psychological harm if she is forced to reveal her identity to the public. So, what people need to understand is when you reveal your name, it's not about, how can I say this? Everybody has their opinion. People will think that because they don't identify their names, that they may be out there for money, and that's not the case. When people learn of these individuals' names, they look at them totally different. And then, oh yeah, she's all about the money or he's all about the money, and that's not the case. But when you are subject to public ridicule, then whoever was thinking about coming out and telling their story and doing something about it, they're like, "Oh my god, this person just got shot down. I don't want to go through that." So this here is in place so that people are able to report these type of crimes and do what they need to do to get justice. So people have to really understand that. All right, so that was the memorandum from Tony Buzbee to support their motion to continue as Jane Doe, and that's the order. All right, now so Tony Buzbee has filed all of that stuff. Here comes Jay-Z's attorney. So he's also using Alex Shapiro. So if y'all don't know who Shapiro is, y'all got to look at these Diddy cases. That is also one of Diddy's attorneys. So that is Jay-Z's attorney, Alex Shapiro. So he has filed his notice of appearance. As soon as he did that, he went ahead and he filed a motion to deny plaintiff's request to proceed anonymously. Whew, this is, boy, when I say this is about to be a battle. This is really about, and Jay-Z is not backing down. I don't have a stance on, whether I think he did it or not. I'm just optimistic is not the word. I'm just going to sit back and observe because people said the same thing about Diddy, and look what happened. So I'm just sitting back and I'm just looking at everything, taking it all in and formulating my opinion, but I'm just going to keep that to myself. All right, so on to Alex Shapiro's, Sean Carter's attorney. He files a motion to deny the plaintiff's motion to proceed anonymously. So it says, please take notice that upon the accompanying memorandum of law and the exhibits attached thereto, and any other argument or materials that the court may consider before this motion is taken under submission by the court. Defendant Sean Carter will move this court before the Honorable Judge Jessica G.L. Clark at a date and time to be determined by this court and pursuant to the Federal Rules of Civil Procedure. And they're asking for the plaintiff to refile her complaint with her true name or an alternative dismissing the plaintiff's amended complaint pursuant to Rule 12 of the Federal Rules of Civil Procedure. So pretty much what they're saying is you either refile your complaint with your name or dismiss your case. But this is just a request because it's only a motion. Motions only requests are only requests. When you file a proposed order, it is up to the judge whether or not he is going to grant that request. Now, as I read in the beginning, one of the paralegals in the paralegal group, she stated that the judge in this case has already signed an order allowing for the attorney to file as Jane Doe. So this was before Jay-Z was added to the amended. So I'm just curious as to what is going to happen if he's going to say this motion to deny it is denied only because there was already an order signed stating that the plaintiff is allowed to continue as Jane Doe. All right, so that is his motion. And then in support of the jayz's motion, and I'm not reading all that because it's 29 pages, but their argument is that the plaintiff's motion should be denied in full and her identity disclosed immediately as required by the federal rules. And then their second argument is in the alternative, the court should dismiss the complaint under federal rules of civil procedure, um, rule number 12. You're welcome. Thank you so much, Tila, for coming over here and listening to me read. I had to take a break because I am in the middle of doing discovery, and sometimes it's a lot. All right, so going into the first part of his argument, they state that the allegations in the lawsuit are not unique, nor are the circumstances exceptional so as to warrant the extreme accommodation of proceeding anonymously. Multiple judges in this very district to consider these issues have concluded as much and required the plaintiffs to provide the court, the defendants, and the public with their true names, even where the facts and circumstances were more supportive of relief. For example, they stated that where Combs had made a threat, and oh yeah, I remember that case, McCurry versus Combs. And it says because there is even less reason to support an anonymity here, the court should require the plaintiff to reveal her identity or dismiss her suit. So what they're saying is that there's not any in the amended petition. There's not any significant changes or anything out of the ordinary compared to all of the other suits. I'm going to tell y'all this: when we draft petitions, the language is going to be the same. The only thing that is different is the facts of the case, if that makes sense. I would show y'all a couple of positions, but honestly, when we draft petitions, that's what it is. Now we cater to, the facts of the case, and that's what's, inserted into a complaint, but it's going to sound redundant and it's going to sound like the petition before, only because that's how we draft it. So you have to just really take a look at the facts and the allegations versus, all the other information. So one thing they stated is that the motion to support using a pseudonym, they stated like, okay, this is highly sensitive and it's very personal. So jayz's attorney was like, okay, well, let's talk about this. So plaintiff's allegations, as pleaded, are highly sensitive and personal in that they describe an SA, to be sure, one that Mr. Carter was not involved in. However, allegations of SA by themselves are not sufficient to entitle a plaintiff to proceed under a pseudonym. And then here they go listing stuff. All right, so that's the first part. Then they're going to talk about the risk of harm to plaintiff or third parties. So the second factor is whether identification poses a risk of retaliatory physical or mental harm to the plaintiff, or even more critical, to innocent non-parties. So in this particular case, says the plaintiff offers. Oh no, they actually took that. They cited that from that case. It goes on to say that the plaintiff offers no evidence of any actual risk of harm or harm to her whatsoever. Instead, attorney Buzbee makes the speculative and conclusory allegations that appear to pertain primarily to other clients of her counsel, not to her. Okay. So because she has not addressed what type of threats or harms that, were previously made, they don't think that she doesn't have evidence that anything has happened to her or will happen to her. But I don't know what to say about this one. Um It says courts have routinely rejected attempts by litigants to shoehorn themselves into a narrow exception to the names disclosed rule through such conclusory, second-handed declarations. Mr. Carter denies the allegations, has no idea who plaintiff is or who she could possibly be. Oh, somebody's calling me. I'll do that. Um, and thus has no, well, I'm sorry, and thus has had no non known contact with plaintiff for approximately 20 years since the alleged incident, which, even if occurred, did not involve Mr. Carter, and there is no allegation of any threat to plaintiff in the complaint. This one is quite different. And the reason why I say that, because in reading that complaint, it stated that Puffy entered the room, another female celebrity entered the room, and Sean Carter entered the room. And if I'm not mistaken, in 2000, Diddy was dating Jennifer Lopez. So if y'all didn't know that, y'all better go do y'all research. So what are you saying that did now? I'm just allegedly it was Carter, Sean Carter, aka Jay-Z, Jennifer Lopez, and Puffy. But we shall see. We shall see over time. Um, Mr. Carter is a regarded public figure represented by competent counsel who, in contrast to plaintiff's counsel, oh, that was he shaded him, bro. Listen, listen to what he just said. Mr. Carter is a well-regarded public figure represented by competent counsel who, in contrast to plaintiff's counsel, intend to litigate this case through the court system rather than social media. In any event, counsel has not identified any present threat of physical harm to plaintiff from anyone. Child, he shaded Tony Buzbee all the way. Plaintiff's counsel stresses that other alleged victims he represents have stated that Mr. Combs made threats of violence against them or against the client's family members if the client disclosed to anyone the facts of the SA. But there is certainly no allegation that Carter ever threatened to harm plaintiff, nor could he, as he has no idea who she is. So that was a little shade too. Like, hey, look, y'all said Combs is the one who made the threats. That ain't got nothing to Jay-Z. Jay-Z didn't threaten nobody. Y'all got the wrong guy. And further to add to that, Jay-Z doesn't even know who she is. And so that's why Tony Buzbee said, let's continue to use the pseudonym Jane Doe. However, we are more than happy to let the defendant know who the individual is. Plaintiff's counsel asserts, without offering any evidence, that plaintiff would certainly experience mental harm if she is forced to reveal her identity to the public. In this context, public humiliation is not enough. Oh my gosh. Nor is it sufficient for plaintiff to put forth a generalized argument that revealing the identity of a victim of SA would further victimize her. Accepting such argument would be to hold that nearly any plaintiff alleging SA could proceed anonymously, which simply is not the law in this circuit. Oh man, there's I give it to them. They are actually they're citing some good cases. They're citing some good cases. I don't know, man. I don't know. I'm not going to read all of this because, child, let me see. Plaintiff age weighs against. Plaintiff is not especially vulnerable, particularly in the light of her age. Oh, so they're saying plaintiff is an adult, 37 years old, and she has not identified any reason for the court to treat her as more vulnerable than the great run of adult plaintiffs who bring allegations of SA in their own names. Dang. What they trying to say. She 37 years old. She can handle public scrutiny. That's wild. Yeah, I'm really this right here. Oh wait, hold up. Oh, I thought something said something about my child. Um, oh, I'm so hungry. I gotta eat. I've been fasting. I don't want to go through all this, but yeah. So this is the motion. Pretty. Oh, wait. Oh yeah, and in addition to that, so in addition to Alex Shapiro filing this motion to deny plaintiff's motion to um to deny that motion for her continue anonymously, he also filed exhibits. One of the exhibits is his Instagram, Tony Buzbee's Instagram, and then Tony Buzbee's um, Twitter page to show that he's not really being an attorney. He's really trying to battle this out on social media versus in the courts, which I don't agree with. But this man, I know I just seen a picture on here. Maybe I'm tripping. I think I'm tripping. Y'all could have sworn this man posted a picture of Tony Buzbee when he was a Marine. Oh, there you go. Hold up. All right, let me see. Okay, there is every indication that this lawsuit is not truly about the plaintiff, but about Attorney Busby's larger unsavory agenda. Despite plaintiff's request to proceed anonymously, plaintiff counsel is doing everything to draw widespread attention to her. The same day the amended complaint was filed, naming Mr. Carter, attorney Buzbee posted on Instagram and Twitter prominently featuring himself. If y'all hear my stomach growling, please forgive me. And Twitter prominently featuring himself addressing the amended complaint and making clear this is not about his clients, but is about his personal spat with Mr. Carter, bro. Oh, you know what? And I actually pulled up the Twitter. So, you know what? Let me just exit out of Twitter. Okay, there we go. All right, so here's his this is what Instagram? No, this is Twitter. So, regarding the Jay-Z case and his efforts to silence my clients, Mr. Carter previously denied being the one who sued me and my firm. I found the petition, y'all. We're going to get into that later. He filed his frivolous case under a pseudonym. What he fails to say in his recent statement is my firm sent his lawyer a demand letter on behalf of an alleged victim, and that victim never demanded a penny from him. My God. Y'all hear that? I'm going to reread that. What he fails to say in his recent statement is my firm sent his lawyer a demand letter on behalf of an alleged victim, and that victim never demanded a penny from him. Instead, she only sought a confidential mediation. Since I sent the letter on her behalf, Mr. Carter has not only sued me, but he has tried to bully and harass me and this plaintiff. His conduct has had the opposite impact. She is in Bolden. I'm very proud of her resolve. As far as the allegations in the complaint filed, we will be let we will let the filing speak for itself and will litigate the facts in court, not in the media. All right, so the only thing that I have to say about this, he said that they only sought a confidential mediation. And normally when we do mediations, we are it's like you're mediating a settlement agreement, or well, it depends. It's not always about money. I just thought about that because I'm thinking on the personal injury side, but then I'm also thinking about the family law side because it's not always about money. Because even if, say, for instance, a family law case, they might have mediation to determine, who gets the kids, or something that is non-monetary. So there is a possibility that I don't know what the mediation would have been about. Maybe to talk about, hey, this happened, you seen this happen, or whatever the case may be. But it doesn't have to be about money. So I was about to say a mediation is all about money, but that's not the case. It's not always about money during a mediation. So I just want to be clear about that. And then this is his Instagram post. I saw this and started laughing because the only reason he posted this was because in Jay-Z's statement, he stated something, oh, you are a Marine. I thought a Marine's supposed to be da 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 da. All right. So it says, recognize this guy. This is a picture of the weapons platoon commander, Alpha Company, 1st Battalion, 4th Marines, from an old Western Pacific cruise book. Despite a coordinated and aggressive effort that has included harassing my kids, contacting my clients and former clients to encourage them to sue me, contacting my colleagues or former employees, asking if I've abused them, showing up at my current employees' homes to harass them, filing frivolous cases against me and my law firm, defaming me with outrageous assertions to anyone who will listen, having mysterious people follow me and my family. I'm still that guy already, Tony. Let me tell you something. He is a national trial attorney. He's not a national trial attorney for nothing. And the cool thing about this is, like I said before, I had a conversation with one of my attorneys, and he put me on. He said there is a difference between a trial attorney and a litigation attorney. All right, a litigation, you may not ever make it to trial. Okay, you may not make it to trial, but you have to know exactly what you're doing in a litigation game. But when you go to trial, that's a whole different ball game. That's a whole different genre. You have to know how to work it. And so Tony Buzbee is that guy. Whether people like it or not, Tony is that guy. Now, I ain't putting down anybody else because one of the attorneys I work for, he is that guy too. But he does, he does PI just like, Tony Buzbee, but Tony Buzbee is more on a national scale versus, a I'm just going to handle Texas type of guy. I won't be bullied or intimidated. People will see through this effort to discredit me and my clients, and the truth will be revealed. I also won't allow anyone to scare my clients into silence. Sunlight is the best disinfectant, and I am quite certain the sun is coming. And that is the key thing there, because it'd be different if you wasn't doing anything, if you wasn't, contacting family members, former clients, current clients, all this other stuff. That's just going above and beyond. So hey, you want to do this publicly? I'm gonna show you publicly. So I don't. Hey, shout out to Tony Buzbee. I ain't gonna lie. Buzbee is the guy. He is the guy. So yeah, so that's it. That is it for now. I was gonna show you the Twitter post, but he already included that in there. So to sum it up, last night after the amended complaint, Tony Buzbee filed a motion to continue this case under Jane Doe. Alex Shapiro, who is also Diddy's attorney, put in a notice of appearance for Sean Carter, and he also filed a motion to deny plaintiff's motion to continue under the pseudonym Jane Doe. And that is where we are right now. From what one of the other paralegals said is that the judge has already signed an order for them to continue, to file this case under Jane Doe. So I believe that it should apply to the whole case, but we shall see. That's the only thing. But y'all tell me what y'all think about this attorney beef, the beef of the attorneys. I love it. Put it in the comments below. Don't forget to like, share, and subscribe. Until then, be blessed, and I'm out. Bye.